Okay. For today's topic, I'll be discussing the rules and limitations in the grant of probation, na kung saan explain natin kung ano ba yung nature of granting probation, sa pagbibigay ng probation to be specific ng ating court, as well as sino ba yung qualified and disqualified convicted offenders na pwedeng mabigyan and hindi mabigyan, of course, kapag disqualified, kapag sila is nag-apply or nag-petition for probation. And then, we'll be able also to discuss and understand kung ano ba yung procedure in the application of probation, as well as ano ba yung trabaho ni court, again, and ano ba yung trabaho ng ating probation officer, and ano ba yung use ng PSI or the PSIR, the post-sentence investigation, for the grant or denial ng ating korte sa petisyon ng ating aplikante for probation. So, lahat ng yan po is pag-uusapan natin ngayon. So, simulan natin sa grant of probation. I-discuss muna natin siya in general kasi mamaya himay-himayin pa natin yan. So, for the grant of probation, this is subject to the provision of, again, the PD 968. To be specific is the section 4 of the PD 968 wherein ang sabi dyan, the court may, after it shall have convicted and sentenced a defendant, and upon application, suspend the execution of said sentence and place the defendant on probation for such period and upon such terms and condition as it may deem best. Sabi dyan, the court may. So, ibig sabihin, ang korte yung nagde-decide whether he will grant or deny the petition for probation ng ating aplikante. First, si court yung nag-grant or nagde-deny. Pangalawa, sabi dyan, the court may. So, ibig sabihin, dahil nga ang probation is not a matter of right, but a privilege na binibigay sa ating mga convicted offenders, it is upon the discretion of the court kung ibibigay niya ba ito sa aplikante or sa petitioner or not. So, again, depende pa rin yan sa magiging desisyon ng ating judge or ng korte, to be specific, kung karapat-dapat bang bigyan yung ating aplikante or petitioner kahit sabihin natin that it appears na siya is qualified based dun sa qualification, but still, kung makitaan niya ng korte na hindi siya karapat-dapat bigyan, so wala tayong magagawa. Again, si court ang nagbibigay and the court may. Diba? The court may grant or not. Diba? Deny the application or ibasura yung petisyon ng ating aplikante for probation. Next, after it shall have convicted and sentenced a defendant and upon application. So, the court may, after it shall have convicted. So, meaning to say, hindi pwedeng bigyan, diba, ng probation. Hindi pwedeng bigyan ng probation or i-deny ang probation at first kung hindi pa convicted yung ating nasasakdal. So, dapat dyan, convicted offenders, diba? Shall have convicted. So, dapat meron ng judgment of conviction. To be specific, siya is napatawa as guilty and nabigyan ng sentence. Shall have convicted and sentence, so meaning to say, convicted as guilty and nabigyan ng sentence and upon his application. So, nakalagay dyan. First, again, yung court, and then, dapat dun sa trial niya, diba, dun sa judgment na binigay, siya ay guilty, and then napatawan ng sentensya. Now, dapat merong application na mangyayari upon the application nino ng atin pong convicted offender. So, mamaya mapapalawak pa natin yan. So, dapat, again, the grant or denial, hindi yan magpo-proceed kung walang application na mangyayari na ginawa ng ating petitioner o ng aplikante, or to be specific, yung convicted offender na gustong mag-apply ng probation. So, upon application, now, Upon his application, nakitaan ng court na karapat-dapat siya or walang dahilan para i-deny yung kanyang probation, ang gagawin ngayon, suspend the execution of the said sentence. So, meaning to say, nag-grant yung kanyang petition for probation. Ang mangyayari ngayon, he will place now on probation, kasi nga nabigyan na, for such a period of time. For such a period of time na mamaya madidiscuss natin kung gaano ba katagal yung probation ng ating probationer once na siya is nabigyan ng probation. So, meron niyang maximum term of service, di ba, na siya is mag-undergo ng kanyang probation period. So, mamaya, again, madidiscuss natin yan. And lastly, upon such terms and condition as it may deem best. So, na-release na siya, diba? Sinuspend yung kanyang execution and he will put back into the community, diba? Instead of putting him into jail, ikukulong siya is palalayain, diba? He will place on probation for such a period of time and then subject still to the condition or dun sa terms and condition na i-impose sa kanya ng court as it may deem best. Kung ano yung best para sa kanya, para matulungan siya, para ma-rehabilitate siya, as well as kung ano ba yung best para sa community. So, ganun po yung granting of probation. Okay, next. Sabi din dyan, probation may be granted whether the sentence imposes a term of imprisonment or a fine only. So, mamaya madidiscuss natin kung ano ba yung exact numbers of years o yung exact maximum term of imprisonment na nire-require ng batas para masabi natin na pwede kang mabigyan ng probation. Kasi meron po tayong exact years of imprisonment, to be specific, ng PD 968 para masabi natin again na karapat-dapat siyang maging qualified for the grant of probation. That is the general rule. We have years of imprisonment and then as well as kung magkano yung fine niya. But then again, meron din tayong other grounds para masabi natin na pwede pa rin siyang ma-disqualified. Again, depende kasi yan sa discretion ng ating court. So, mamaya didiscuss natin yan. And then next, an application for probation shall be filed with the trial court. So, balikan natin ulit. Saan siya mag-a-apply? So, within or with the trial court na kung saan doon din nag-undergo yung kanyang trial proper o within the same court na kung saan doon hinear and tinry yung kanyang case. Yung may jurisdiction over him na kung saan doon ka hinatulan, doon ka nabigyan ng sentensya. So now, with the notice to the appellate court, if an appeal has been taken from the sentence of conviction. Kasi mamaya madidiscuss din kasi natin yan na kung saan you have to choose whether you will appeal sa higher court o mas pipiliin mo na mag-avail ng probation. Kasi once na ikaw ay nag-apela sa taas, ibig sabihin, winave mo na yung chance mo or yung right mo to probation, lalo na kung pasok ka dito sa privilege na to at hindi mo inavail. Mas inuna mo yung mag-apela, so now wala ka ng chance to apply or to petition for probation kasi nga nag-apela ka na to higher court. So bawal pagsabayin yon. You will choose whether you will appeal or to avail probation or to petition for probation para ikaw ay makalaya na agad. So kaya naman kailangan niya na with the notice dun sa appellate court, if there is an appeal na nangyari, once na siya is nabigyan ng judgment of conviction. So, once na ikaw ay nabigyan ng hatol na ikaw ay guilty at nasintensyahan ka, automatically naman yan, pipili ka kung aapela ka or ito nga, kung pasok ka sa probation, mag-avail ka ng probation. So, mamaya, madidiscuss pa ulit natin yan. So, next, the question is, will probation be automatically granted to one whose sentence is 6 years or less? So, eto na yung sagot kanina. And then, madidiscuss pa rin natin yan mamaya. Ano yung maximum term of imprisonment na pasok ka for probation? At eto yung sagot doon. Yung convicted offenders natin, whose sentence is 6 years or less. Ibig sabihin, the maximum term of imprisonment should be 6 years and pababa na yon. Hindi pwedeng 6 years and above. So, meaning to say, kapag yan ay lumagpas ng 6 years, hindi ka napasok or hindi ka na qualified for probation. Sabihin natin, maximum term of imprisonment mo is 6 years and 1 day to ganto, automatically, ikaw po is disqualified for probation. So, going back, the question now is, will probation be automatically granted to one whose sentence is 6 years or less? Automatic ba na iyan ay ibibigay ng korte sa iyo kahit hindi ka nag-apply or sabihin man natin na nag-apply ka, pasok ka sa qualification, ibibigay ba yan sa iyo agad-agad ng korte? The answer is no, kasi meron tayong tatlong reason kung bakit again, 'di ba? It is upon, 'di ba? Solely dependent tayo dun sa discretion ng korte kung ano ba yung mas makakabuti sa ating offender, convicted offender to be specific, at sa ating community. Kasi nga, hindi iyan karapatan. It is not a matter of right, but a privilege na ibinibigay ng batas para sa ating mga convicted offenders. Again, the answer is no. Hindi siya automatic na binibigay sa ating mga qualified offenders. First, kapag ang ating convicted offender is in need of correctional treatment that can be provided most effectively by his commitment to an institution. Ano yung ibig sabihin yan? Ang sabi lang dyan, mas makakatulong daw sa ating petitioner, sa ating aplikante, na magstay inside the correctional institution para dun niya makuha yung correctional treatment na karapat-dapat para sa kanya na hindi niya maa-attain or hindi sa kanya ay maibibigay kapag siya is nasa labas ng kulungan. Ibig sabihin, ang assessment dito, mas makakatulong sa'yo kapag ikaw ay kinomit namin inside an institution rather than putting you into the community na most probably mas makakasama pa lalo sa'yo. So, yun yung unang reason. Pangalawa, there is undue risk that during the period of probation, the offender will commit another crime. So, meaning to say, ikaw is magpo-post, diba, ng kapahamakan outside the community. Malaki yung posibilidad na kapag ikaw ay binigyan ng pagkakataong makalaya, sa halip na ikaw ay magtino, lalo ka pang makakasama. At the same time, lalo ka pang mapapasama. So, mas maganda na ikaw ay nasa isang institusyon, ikaw ay nakakulong, di ba? Merong nagbabantay sa'yo at mapipigilan ka to commit, di ba? To recommit another crime at makadiskrasya ka pa ng ibang tao, di ba? To be exact, di ba? In short, ikaw ay hindi pa dapat pagkatiwalaan dun sa trust na pwedeng ibigay sa'yo ng korte na ikaw ay susunod, di ba, dun sa condition na ibibigay, sa terms and condition, kasi in the first place, ikaw ay posible pang manggulo rather than choosing na ikaw ay sumunod, di ba, dun sa terms and condition na ipapatupad sa'yo ng korte. So, no, ikaw ay makakasama lang kapag ikaw ay lumabas. So, dapat dito ka na lang sa kulungan at mamomonitor ka pa. And then lastly, probation will depreciate the seriousness of the offense committed. Diba? On the part of the victim as well as dun sa mata ng ating community and sa mata ng batas, diba? Gantong kabigat yung kasong ginawa mo. And then probation lang agad-agad yung magiging kalutasan sa problema mo, sa pagkakakulong mo. Paano naman dun sa gravity ng offense na ginawa mo? Di ba? Yung seriousness ng offense na nagawa mo as well as dun sa sense, ano ba si batas? Di ba? Nakakabawa sa gravity ng offense na ginawa mo kung ikaw ay bibigyan ng ganun-ganun lang ng kalayaan ng dahil sa probation. So, depende yan sa ating court again, di ba? Kung ikaw ay bibigyan, especially kung ito yung factor na tinitingnan niya. Nakakabawas dun sa gravity ng offense na na-commit mo, dun sa krimen na nagawa mo, and then yung solution mo again is probation lang. 'Di ba? On the part of the community, 'di ba? On the eye of the community, on the eye of the victim, as well as dun sa nagke-carry ng batas, 'di ba? Sa nagpapatupad ng batas and the law itself, 'di ba? Medyo bias tayo dun sa part na yon, or hindi naman kaya kasobrahan na yon, 'di ba? Dun sa privilege na pwede niyang makuha. Okay, next question, is probation a right? So nasagot na natin yang kanina. No, it is a mere privilege for adult offenders. So in short, again, ang probation po is not a matter of right but a privilege na binibigay po sa ating mga convicted offenders. It cannot be demanded ng ating convicted offenders as their matter of right kasi po ito is a privilege. Only those who are qualified may apply for probation, and again, yung grant nito is nakadepende dun sa discretion ng ating court. And there should be no person or convicted offender na mabibigyan ng probation except upon the prior investigation na madidiscuss natin. So again, ang probation po, it is a matter of privilege, hindi po karapatan, kaya naman nakadepende pa rin tayo sa discretion ng ating court. However, under ng RA 9344 or the Juvenile Justice Welfare Act of 2006, ang ating CICL or yung ating child in conflict with the law o yung mga juveniles natin na offenders is granted the right to probation as alternative to imprisonment if qualified under the probation law. So automatically yan na ibibigay sa ating mga child in conflict with the law as an alternative to their imprisonment. Kasi 'di ba ang pagtitreat natin sa mga kabataan natin, 'di ba, na naka-commit ng krimen is as much as possible hindi natin sila igaya dun sa ating mga adult offenders na ikukulong, 'di ba? Na isasama natin sa kanila sa kulungan, but instead we have this kind of alternative para sa kanila na sa halip na sila ay ikukulong, 'di ba? Ang kabataan natin or yung CICL natin is granted the right to probation. Again, dun sa provision natin under ng RA 9344 or Juvenile Justice and Welfare Act of 2006. And the next, how many times can one be granted probation? And the answer is only once. An offender can be granted probation only once in his lifetime. So hindi po unlimited ang ating probation once na ikaw is na-enjoy mo na yung privilege, 'di ba? Na ikaw ay nabigyan ng probation noon nung ikaw ay nakakommit ng krimen. So now, pasaway ka ulit, 'di ba? Nakagawa ka ulit ng krimen, and then your crime na na-committed is pasok pa rin kay probation, hindi ibig sabihin na ikaw ay qualified pa rin is bibigyan ka ng probations. So no, you can apply only for once. So kung gusto mo mag-apply ulit, edi i-try mo, pero hindi yan igagrant ng ating korte. Kasi ito po is binibigay lang only once, so isang beses lang in his lifetime. Okay, next. Is granting or denying probation appealable? Kapag ikaw ba ay nabigyan or especially kapag ikaw ay hindi nabigyan or na-deny ang iyong application for probation, pwede ka bang mag-apela? The answer is, an order of granting or denying probation shall not be appealable. Diba? Again, especially kapag iyan ay na-deny, wala kang karapatang magreklamo or wala kang karapatang mag-apela sa korte dahil again, kahit sabihin natin na ikaw ay qualified, kinwestiyon mo yung desisyon, bakit po ako is hindi nabigyan ng probation, qualified naman po ako base dun sa qualification and disqualification, hindi po ako disqualified, and then especially ako po ay qualified, pasok po dun yung qualification ko. Again, tayo po is nakadepende pa rin sa desisyon and discretion ng court. And then next, no application for probation shall be entertained or granted if the defendant has perfected an appeal from the judgment of conviction. The application for probation was no longer allowed if the accused has perfected an appeal from the judgment of conviction. So napakalinaw naman that no application for probation shall be entertained or granted kapag ang defendant natin is nag-apela from the judgment of conviction. When we say judgment of conviction, ikaw is nabigyan ng pagkakahatol na ikaw ay guilty. Judgment, di ba, when we say judgment, di ba, the final verdict or the final giving ng ating korte ng desisyon kung ikaw ay guilty or not. So you have the judgment of conviction wherein ikaw daw ay guilty. So kapag ikaw ay nakatulan ng guilty, di ba, ang choice mo naman is mag-apela. So once na ikaw is nag-apela, di ba, you have already perfected an appeal from the higher court. Again, no application for probation shall be entertained. Hindi i-grant yung iyong petition or application for probation. Again, the application for probation was no longer allowed if the accused has perfected an appeal for the judgment of conviction. So, napakalinaw naman. Bawal po pagsabayin, di ba? Nag-apela ka na, mag-a-apply ka pa kay probation. So, naninigurado ka. Kapag nag-apela ka sa taas and then guilty ka na naman, meron kang panibagong choice o kaya meron kang panambot, di ba? Akala mo, di ba, pwede yon? So, no. Hindi pwedeng mamangka ka sa dalawang ilog. Pumili ka sa dalawa, and then, swerte mo na lang kung nag-apela ka, and then, ang pangalawang hatol sa'yo is hindi ka guilty. Pero kung guilty ka na naman, di ba? So, sorry na lang. Hindi ka na po pwedeng mag-apply for probation, pero meron naman tayo dyang exception sa rule na yan. Diba? As a general rule, kapag ikaw is nag-appela to the higher court, bawal at bawal pong mag-petition for probation. If ever na ikaw ay mag-apply, yan po is hindi i-grant ng ating court. But, kung ang nangyari naman, for example, is ang convicted offender natin na nakatanggap ng judgment of conviction, guilty, and yung sentence niya, di ba, at first, is lagpas sa 6 years. Sabihin natin na 8 years pataas yung kanyang sentence na binigay sa kanya. So, automatically, wala naman siyang choice to apply or to petition for probation. Ang pipiliin na lang talaga niya is to appeal. So now, nag-apela siya sa taas. Still, yung desisyon ng korte is judgment of conviction. Guilty pa rin siya. But the good thing is, yung korte, di ba, binabaan yung sentensya mo. The judgment from the appellate court or dun sa higher court kung saan mo tinaas yung korte mo makes your penalty lower. From 8 years kanina, dun sa pangalawang desisyon nila, ikaw ay guilty pa rin, pero pinababa nila yung sentensya mo to 6 years, to be exact. Now, you have your choice now. Kanina kasi, wala kang choice kundi mag-apela lang. Ngayon, dalawa na yung choice mo. Kung mag-aapela ka ulit to the higher court, diba? Kung yan naman ay abot ng Supreme Court, or so whatsoever, diba? Nag-apela ka pa ulit, or kung gusto mo ulit mag-apela, or you have your another choice to apply for probation kasi pasok na yung iyong years of imprisonment, yung maximum years of imprisonment mo to apply for probation, which is 6 years. So, ano yung ibig sabihin natin dito? Pwede ka pong mag-apply for probation kapag ganun yung nangyari. Dahil pasok na yung iyong kaso dun sa probationable period of imprisonment mo, or probationable term of imprisonment mo sa probation, which is the maximum of 6 years. Nung una kasi, di ba, wala ka again choice. Di ba? Yung choice mo lang is mag-apela. Now, kapag ang korte, di ba, na kung saan ka nag-apela, binabaan yung kaso mo at pasok dun sa probation period or terms of imprisonment na pasok dun sa sinasabi ng batas, pwede ka pong mag-apela pwede ka pong mag-petition for probation. But, kung simula pa lang, di ba, sabihin natin na ang kaso ko again is a maximum of 6 years. At first, di ba, simula pa lang, meron na akong dalawang choice. That is to appeal. Diba? Hindi ako papayag na guilty ako, mag-a-appela ako. And then, another choice mo is to apply for probation kasi probationable yung iyong kaso. you choose to appeal. So, sorry ka, kapag nag-apela ka, judgment of conviction pa rin yung kaso mo. Tapos, sasabihin mo ngayon, mag-a-avail na ako ng probation. So, it is a no po. Hindi na po pwede. Dahil, at first pa lang, you have given the chance to choose between to appeal, di ba? Or to petition for application, pero mas pinili mo na mag-apela. So, bawal po yun. Kung sa simula pa lang, probationable na yung kaso mo, ba't hindi mo na lang piliin si probation? So, kapag pinili mo si probation, di ba, win-win din naman yung situation. But, kung sa simula pa lang is non-probationable na, ibig sabihin, hindi ka naman pasok talaga sa probation, you have no choice. Kundi mag-apela kung gusto mong mag-apela. Kaya naman, again, yung senaryo kanina na nag-apela ka, but guilty ka pa rin, but the good thing is napababa yung kaso mo, pwede ka pong mag-apply for probation. But take note po, hindi po nangyayari yung ganong mga pagkakataon kadalasan. Hindi yun assurance na pipiliin ko na lang na mag-apela ako, baka kasi mapababa yung kaso ko. So no, wala tayong assurance na ganun yung mangyayari. But then again, may ganung pagkakataon pero wala tayong assurance kung pwede bang maging applicable yun sa'yo, na mapababa yung kaso mo, and then maging probationable yung term of imprisonment mo. I mean, maging probationable yung sentence na ibibigay sa'yo, wherein pasok dun sa term of imprisonment na nire-require ng batas. So, kung ganun yung mangyari, mapalad ka, pero kung hindi ganun yung mangyari, di ba, nag-apela ka na, guilty pa rin, and then hindi pinalatan yung terms, or I mean, yung sentence mo, mataas pa rin, so sorry. So again, it's your choice. Sorry, parang kayo yung kriminal. So, it is the choice of the convicted offender kung siya is mag-aapela or not. Okay, next. Who are qualified to probation? So, ito na yung kaninang pinag-uusapan natin. Sino ba yung qualified to apply for probation? So, any first-time offenders convicted of crimes punishable by imprisonment of not more than 6 years. So, to be specific, a maximum of 6 years dapat yung sentence na binigay sa'yo. Diba? Yung years of imprisonment mo dapat is a maximum of 6 years, wala nang pasobra pa. So, ibig sabihin, kapag 6 years and 1 day, and then meron pang sumunod na year, 6 years and 1 day to 8 years, diba? Hindi na po pwede yon. A maximum of 6 years, kahit 1 day pa yung sumulpot dyan, bawal po at hindi ka po qualified for probation. So, generally speaking, diba, as a general rule, ang probation natin is applicable for all convicted offenders. Diba? Kasi naman, ibinibigay lang ang probation kapag convicted na yung tao. But, then again, diba, we have specific terms of imprisonment na kung saan pasok lamang sa probation. At yun na nga po yung maximum of 6 years. Kahit sabihin mo na ikaw ay convicted offender ka, di ba? Hindi ibig sabihin na ikaw ay convicted na, pwede ka for probation kasi dapat yung years ng sentence mo, again, is a maximum of 6 years, and again, any first time offenders. Any first time convicted offenders. Pangalawa, should be 18 years and above. And lastly, not otherwise disqualified under the PD 968 as amended can apply for probation before serving the sentence, which may either be imprisonment of fine with subsidiary imprisonment or both imprisonment and fine. So, not otherwise, hindi ka disqualified as prescribed or as given by the provision, di ba? Subject to the provision na given under ng PD 968 na mamaya i-discuss natin. Ano ba yung disqualification? Sino ba yung disqualified offenders? So first, ang ating qualified, we have a maximum years of imprisonment which is 6 years lamang. 6 years pataas, automatically disqualified. Pangalawa, 18 years and above. And then lastly, automatically qualified ka kapag hindi ka pasok dun sa disqualification under ng PD 968. Okay, next. Ano ba yung disqualification ngayon na pinag-uusapan natin? Sino ba yung disqualified offenders for probation. So, under pa rin yan, of course, ng PD 968, to be specific, under ng Section 9 of PD 968, yung benefits of probation shall not be extended to the following. Those sentenced to serve a maximum term of imprisonment of more than 6 years. So, sinagot lang natin yung kanina. Dahil ang qualified offenders is yung imprisonment is maximum term of 6 years. Ibig sabihin, 6 years or less. Ito naman, disqualified ka automatically kapag ang maximum term of imprisonment mo is more than 6 years. Ibig sabihin, 6 years and 1 day pataas. Disqualified ka. Pangalawa, those of any crime against the national security. So, to be specific, di ba, dun sa ating criminal law, we have crimes against national security. So, yan po yan. From treason up to the last, the qualified piracy. Again, wherein meron tayong specific na crimes na nakapag iyan yung kinumit nung tao, nung ating convicted offender, siya is guilty of that crimes, diba? Diyan sa mga crimes na nandyan, automatically disqualified siya for probation. Next, those who have previously been convicted by a final judgment of an offense punished by imprisonment of more than 6 months and 1 day and or a fine of more than 1,000 pesos. Those who have been previously convicted. So, ibig sabihin, ikaw ay previously napatawan na ng, ng judgment, ikaw ay previously convicted na of a crime, of a specific crime, na kung saan yung offense na nagawa mo is punishable by imprisonment of more than 6 months and 1 day or a fine of more than 1,000 pesos. Yan yung tinutukoy natin kanina, na mayroon ding specific na years. And then, na specific na fine na kung saan kapag lumagpas doon, ikaw ay disqualified. At iyan na nga po yun. And that is as amended by the RA 10707. So, try to review the RA 10707 na kung saan meron tayong specific na provision sa PD 968 na nirevise nila or inamend nila, So, ito na yung isa dun sa amendment na ginawa nila. Those who have been previously convicted na kung saan ang imprisonment is 6 months and 1 day and a fine of more than 1,000 pesos. Next, those who have been once on probation under the provisions of PD 968. So, sabi nga natin kanina, diba, ito is binibigay lang only once, diba, sa ating mga convicted offenders. So, once na ikaw ay nabigyan niya ng noon, and then umulit ka na naman sa krimen na nagawa mo, diba, sabihin natin na probationable pa rin yung nagawa mong krimen, hindi ka na pwedeng mag-apply for probation. Hindi na yan ibibigay ng korte sa'yo kasi isang beses lang and at first, hindi yan karapatan, di ba? Na na-enjoy ng lahat ng convicted offenders. That is privilege na pwede mong ma-enjoy, di ba? Only once. Okay, next. Those who are already serving sentence at the time substantive provision of the decree became applicable pursuant to Section 33 of the PD 968. Ano yung tinutukoy natin dito? Yung mga convicted offenders natin na nagsaserve na ng kanilang sentence nung itong PD 968 ay naisabatas na. So, lahat ng yon hindi nila naabutan to, di ba? Nakakomit na sila ng krimen bago pa naipasa tong batas na to, hindi po nila may enjoy ang privilege na ito. So, ganun lang yon. Ngayon naipasa yung batas, di ba? Kahapon ka nakulong, so hindi mo ma-enjoy ang privilege na ito. Pero di ba, ma'am, bakit po parang salungat yan dun sa no ex post facto law na exemption, di ba, na rule? Di ba, na kung saan, balikan natin, what is ex post facto law na pinag-uusapan natin? Di ba, again, dun muna tayo sa general rule about this law. No ex post facto law shall be applied or pass. Ayan yung rule natin. The general rule, walang ex post facto law na maipapasa Na kung saan, di ba, ano yung meron dyan? Kasi daw, kapag ginawa dapat ang batas, dapat daw prospective ito, di ba? Prospective ang application nito. Na kung saan ibig sabihin dapat pasulong, di ba? Paabante yung pagsusulong ng batas nito at hindi pa urong. So meaning to say, yung mga maaapektuhan ng bagong pasang batas is yung naabutan lang during the proper implementation ng batas na to. So, hindi dapat masagasaan ng batas na to yung noon pa man, bago pa maisa batas to, is hindi pa naman existing, di ba, yung batas na to. Bakit sila maaapektuhan? Bakit sila maaapektuhan? Ngayon lang naman napasa tong batas na to. So, hindi daw dapat sila maapektuhan dahil, again, prospective dapat ang application ng batas na ito at hindi pa urong, di ba, kundi pa sulong. Yun yung general rule. But, we have exemption to the rule, di ba, wherein kapag ang application ng batas na ito is favorable dun sa offender. Again, that is the general rule. Dapat prospective tayo. Pasulong tayo at kung ano man yung batas na napatupad, hindi dapat maapektuhan yung lalo na't nag-serve na ng sentence o nakagawa ng krimen during that time na hindi naman existing pa yung krimen na yon. But we have exception to the general rule or we have the exception to the rule. Pwede siyang i-apply retroactively kapag favorable sa offender. So, meaning to say, kapag favorable sa ating convicted offender, yung bagong pasang batas, pwedeng i-apply sa kanya yon. The question now is, ma'am, bakit po ganon? Favorable naman po yung probation para sa convicted offender, lalo na po kapag siya is qualified. Bakit hindi pa rin siya pwede? Bakit po disqualified pa rin siya? The answer is, dun sa exception to the rule, we have still exception to the exception to the rule. We have the general rule, no ex post facto law shall be enacted or passed, di ba, or applied. And then, the exception to that rule is pwedeng i-apply kapag favorable kay offender. And then, to that exception, we still have exception to the exception to the rule. At ano yon? When the law specifically provides. That's it. Kapag yung law na mismo yung nagsabi, hindi pwede, hindi pwede. Kahit sabihin mo na favorable pa yan, again, when the law specifically provides, kung yan man ay i-apply natin or hindi. Since then, ang PD 968, we have this final disqualification na nakasulat that those who are already serving their sentence at the time substantive provision of the decree became applicable. So, the PD 968, binigay niya yung disqualification na yan. So, binigay ng batas na yan na kahit ikaw ay nagsuserve na ng sentence during that time na naging applicable tong batas na to, disqualified ko pa rin. Yun yung tinutukoy natin na kahit, di ba, sa ex post facto law, kapag favorable, pwede mo siyang i-apply retroactively. Di ba? I-apply natin sa'yo, magbe-benefit ka eh. But, we have still exception to the rule kapag yung law na mismo yung nagbigay. And then, ito nga yung binibigay ng PD 968. Kapag ikaw ay nagsiserve na ng sentence, hindi mo pa rin may enjoy ang PD 968 or yung probation na privilege na pwedeng maibigay sa'yo. So, disqualified ka pa rin. Okay, last disqualification are those legally disqualified under the special penal law. So, alam naman nyo kung ano yung special penal law other than the law that we have sa ating criminal law, crimes against person, and so on. So, we have special penal law as a supplement and then other law na existing na meron silang specific na crimes na pinagbabawal. Diba? To be exact, diba? Disqualified ang ating convicted offender at hindi siya makakapag-apply for probation if he found guilty of any election offense, diba? In accordance ng Section 264 ng Omnibus Election Code. So, as well as the RA 6727, automatically kapag ang crime na nakomit niya is under niyan or yung Wage Rationalization Act as amended. And lastly, sa ating drugs, the RA 9165, the Comprehensive Dangerous Drug Act of 2002, except the sections 12, 14, 17, and 17. So, yan po yung ating special penal law. Again, na kapag yan yung crime na nakomit ng ating convicted offenders, hindi siya pwedeng mag-apply for probation. Okay, next is there a need to apply for probation to avail of its benefit? The question says that kailangan bang mag-apply pa for probation muna bago ka mapigyan nito? So, na-discuss na natin yan kanina. Yes, di ba? It will not be granted except upon the application by the accused or by his counsel. Di ba? Hindi yan ibibigay sa'yo kung walang application na mangyayari. There is a necessity for such application. Di ba? As indicated sa ating section 4, kanina na nabanggit ko, sa PD 968, again, which states that the court may, after it shall have convicted and sentenced a defendant, and upon application by said defendant within the period of perfecting appeal. So, ibig sabihin, hindi ka mabibigyan ng probation kung hindi ka mag-a-apply. So, yun lang yung ibig sabihin yan. It will be given upon the application. Nino ng accused, ng convicted offender o nung kanyang counsel. But again, subject pa rin dun sa pag-aaral ng ating korte kasi hindi porket nag-apply ka, sabihin natin na qualified ka, is mabibigyan ka. Di ba may na-discuss na tayo kanina na 3 grounds na possible hindi ka pa rin mabigyan kung pasok ka doon, as well as yung qualification na binanggit natin and disqualification. So, depende pa rin yan na kahit mag-apply ka, di ba, pwede yang mag-grant at pwede yang ma-deny. Again, no application for probation shall be entertained or granted by the court kapag nag-apela siya sa higher court. From the conviction of judgment, from the judgment of conviction rather, na siya ay guilty, nag-apela siya, bawal po din iyon. Diba? Within the period of perfecting an appeal. Kasi you have 2 choice nga. Diba? Mag-apela ka sa taas or mag-apply ka for probation. At yung period na din yon for probation within 15 days, same as with the period of perfecting an appeal. So, ano yung ibig sabihin nun? So, nabigyan ka ng judgment of conviction, guilty ka. So, you have 15 days, diba? Period na kung saan pwede kang mag-apela. Kapag hindi ka nag-apela, nag-lapse na yon, bawal na. Same lang din yon sa ating application for probation. You have your 15 days, diba, to apply for probation, lalo na kapag probationable ang iyong kaso. Again, by the said defendant, application ng defendant natin o ng convicted offender natin within the period of perfecting an appeal, which to be exact is 15 days from the promulgation of the judgment. From the day na ikaw ay nasintensyahan at napatawan na guilty, bilang ka ng 15 days and within that specific period, ikaw is mag-apply na for probation kapag probationable ang kaso mo, or you have to appeal sa higher court kung gusto mo pang ilaban yung kaso mo. But the point here is, kailangan mo mag-apply para mabigyan ka ng probation. There is a need to apply for probation. Okay, next, is there a form prescribed for the application for probation? The answer is yes. And it shall be in the form that is approved by the Secretary of Justice, diba? As recommended by the administrator or as may be prescribed by the SC. Next. What is the effect of filing an application for probation? So, ano yung mangyayari kapag nag-file ng application for probation ng ating convicted offender? The court may, upon receipt of the application, suspend the execution of sentence imposed in the judgment, lalo na kapag ongoing ang ating PSI or the post-sentence investigation. So, automatically, kapag nag-apply si petitioner sa ating court for probation, the court may, upon the receipt ng application, once na nag-apply ka, 'Di ba? Nagpasa ka ng application form mo sa korte. Upon the receipt na na-receive ni korte yung application mo, isususpend niya yung execution ng sentence na imposed, 'di ba? Doon sa judgment sa pagkakahatol sa iyo. And then, dahil nga sabi ko, you have a pending na PSI or post-sentence investigation within 60 days. So, ganun katagal na days lilipas yung PSI, yung investigation sa'yo, at ganun katagal maibibigay yung probation sa'yo if ever na ikaw ay mag-grant, di ba? Kasi, ang probation officer natin, meron yung 60 days para i-conduct yung PSI, na kung saan nakasalalay pa rin sa PSI kung bibigyan ka ba ng probation or not. Ibig sabihin, hindi porke tinanggap yung application mo for probation is laya ka na talaga, di ba? Nakadepende pa yan again sa discretion ng court at depende pa yan sa hinihintay nating PSI or the PSIR na manggagaling kay probation officer. So while ongoing ang PSI, again, isususpend the court ang execution ng sentence. So you may be allowed, di ba, on temporary liberty, makakalaya ka, pero basta magpiyansa ka. Magbayad ka ng bail mo under his bail. Pwede kang mapalaya under his bail. So, isususpend din yung execution ng sentence mo. Next, where shall an application for probation be filed? So, kanina pa natin yan paulit-ulit. Saan tayo magpa-file ng application for probation kung ikaw man ay convicted offender na nakatanggap ng probationable na kaso? Pasok sa 6 years na maximum term of imprisonment at hindi disqualified. So, the application shall be filed with the court that tried and sentenced the offender. So, in short, mag-a-apply ka for probation dun sa same court na nagbigay ng judgment sa'yo at nagbigay ng sentence sa'yo. The same court who tried and hear your case. So, yun lang yun. It shall be filed dun sa courts that tried and sentenced the convicted offender. So, doon sa korte kung saan ka nahatulan. Next is, when should an application for probation be filed? So, nasagot na natin saan? Sa korte. Now, when? Kanina napasadahan na rin natin to. Kailan? Anytime before the offender starts serving his sentence but within 15 days from the promulgation or notice of the judgment of conviction. So, ito yung binabanggit ko kanina na we have days na kung saan 15 days, di ba, na also considered as the prescribed period, di ba, for perfecting an appeal, di ba, pwede kang mag-apela, or yung 15 days na din yun na pwede kang mag-apela, pwede mo rin yung gamitin for the application for probation. So, kung probationable ang kaso mo, you have 15 days to appeal kung gusto mo mag-apela to the higher court, hindi ka papayag na guilty ka, mag-aapela ka, or kaya naman ikaw ay mag-apply na lang for probation kung probationable naman. So, you have, again, 15 days to apply for probation. However, under Section 42 of RA 9344, the Juvenile Justice and Welfare Act of 2006, the country may, after it shall have sentenced a child in conflict with the law, and upon application at any time, place the child on probation in lieu of service of his sentence. So, iba yung trato talaga natin kapag ang focus natin or yung concern natin, is yung mga child in conflict with the law as compared to sa ating mga adult offenders. So, they have a specific, we have specific rules or we have specific treatment para sa kanila. Okay, next. I-discuss natin now yung procedure under ng PD 968, diba? Procedure for the application ng ating convicted offender sa probation. Once na nag-apply, di ba, ano yung mangyayari? Ano yung mga sumunod na mangyayari? So first, di ba, the offender or his counsel files a petition with the convicting court within 15 days from the promulgation of judgment. So yan muna yung kauna-unahang procedure kasi walang granting, di ba, for probation kung walang application na mangyayari na ginawa ng offender o ng kanyang counsel. Pinakaunang step or procedure, there is a need, diba, na mag-apply sa offender or his counsel Sa convicting court, saan? Sa court na kung saan siya hinatulan. Kailan? Within 15 days nung simulang ng within 15 days, 'di ba? Nung araw na simula na siya is nahatulan. Bilang ka ng 15 days and then yun yung period, 'di ba? Na kung saan pwede kang mag-apela or pwede kang mag-petition for probation. Pangalawa, nag-apply ka na and then pasok dun sa 15 days, 'di ba? Now, the court determines convict qualification. Nagpasa ka ng application form mo, nagpasa ka ng nag-signify ka ng intention mo that gusto mong ma-avail yung benefit ng probation. So now, the court determines yung qualification mo kung ikaw ay pasok. So, pag-aaralan niya ng korte, titignan niya, di ba, kung qualified ka ba or kung pasok ka ba dun sa mga qualification na binibigay ng batas. And, of course, upon his discretion din, di ba, at kung nakita niya that your petition or yung application mo is in due form, di ba, and appears not to be disqualified dun sa grant ng probation, ang mangyayari sa pangatlo is i-refer ni court sa probation officer for post-sentence investigation. So, yan na yung pangatlo. If the court determines that the petitioner is qualified, his application is referred now kay probation officer para mag-conduct naman siya ng PSI. So, mamaya madidiscuss natin ano ba si PSI, ano ba yung role ni PSI at as well as ano ba yung trabaho ni parole, ano ba yung trabaho ni probation officer. So now, qualified daw, nirefer kay probation officer, merong PSI na pinapagawa, ano yung meron ngayon. So pang-apat, kailangan gumawa ni probation officer ng PSIR. The post-sentence investigation now is submitted by the probation officer to the court within 60 days. So meaning to say, upon the receipt nung order, di ba, nung ating court kay probation officer na mag-conduct siya ng PSI, kailangan niyang bumilang ng 60 days. So, within that 60 days, kailangan matapos na yung ating post-sentence investigation. And within that 60 days, kailangan magawa niya na yung PSIR at maibalik at maipasa sa ating court. So, yung 60 days naman na yan yung pinaka nire-require ng batas that within that specific days, number of days, magawa mo si PSIR. But, the court may, in its discretion, na pwede niyang i-extend yung 60 days period na magkoconduct ka ng PSI, lalo na kung meron naman tayong condition, lalo na kung hindi talaga kakayanan within 60 days yung pag-conduct ng probation officer for PSI. Or upon the initiative mismo ng probation officer na mag-motion siya for extension, but yung extension na hihingi niya dapat, mag-notice siya, di ba, sa ating korte 15 days bago pa mag-lapse yung 60 days. So, meaning to say, malapit na mag-60 days, feeling mo hindi pa rin talaga aabot, di ba? Hindi ka pa rin matatapos. So, kailangan 15 days bago pa dumating yung 60 days na yon, mag-inform ka na sa ating korte or mag-file ka na ng motion for extension to conduct yung PSI mo. Dapat 15 days before na mag-60 days, di ba? Na-inform mo na or nag-file ka na ng motion for extension. Na-inform mo na agad-agad. And then, di ba nabanggit din natin kanina na while ongoing si PSI at wala pang PSIR na nakakarating kay court, yung pending ng investigation or yung resolution nga ng PSIR na sinasabi natin, yung akusado or yung convicted offender natin may be temporarily released. Marirelease siya, di ba? Magkakaroon ng kalayaan pansamantala if there is already a bail. O kaya naman magpiyansa ka para makalaya ka habang naghihintay ng desisyon ng korte. But kung ikaw ay sakasakaling ginamit mo yung pagkakataon na yun para makatakas, para makawala, ang tawag na ngayon sa iyo is absconding petitioner. Diba? From ikaw ay convicted offender, ang tawag sa iyo ngayon kapag ikaw ay nag-try to apply for probation, ang tawag sa iyo is petitioner. Now, kung ikaw ay nagloko, diba, while ongoing ang PSI, and then nakalaya ka pa kasi nag-bail ka So, habang naghihintay, laya ka, tumakas ka, o kaya naman hindi ka na makita kung nasaan, from petitioner na tawag sa'yo, ang tawag na ngayon sa'yo is absconding petitioner. Then last, the court grants or denies the petition for probation within 15 days upon the receipt of the PSIR. So, yan na yun. Natapos na yung 60 days, and then ipasa na ni probation officer yung PSIR o yung report kay court. Now, yung korte ulit yung may trabaho na gagawin. Ano yung trabaho ni korte? Pag-aralan niya ulit, di ba? Kung karapat-dapat bang mabigyan or ma-deny yung petition for probation ng ating petitioner. Gaano katagal? Within 15 days upon the receipt of the PSIR. So, for example, today, ibinigay na yung PSIR kay court. So, within 15 days, bumilang tayo, dapat meron na siyang desisyon. It's either he will grant or he will deny the petition for probation ng ating petitioner rather. So, yun yung procedure natin. Mag-start yan from the application ng ating petitioner up to the last na kung saan i-resolve na, di ba, ng ating court. Magkakaroon na siya ng desisyon if he will grant or deny the petition for probation ng ating convicted offender. And then after dyan, i-release na siya, di ba? But subject to the condition that is imposed by the court and to the supervision ng ating probation officer. Okay, next. What is post-sentence investigation? So, yan na nga yung kaninang paulit-ulit nating naririnig. It refers to the investigation conducted by a probation officer to obtain information regarding petitioner's character, antecedents, the environment, the mental and physical condition with the aim of determining whether the latter is qualified and suitable for release under probation. So, nagkakaroon ng investigation, di ba? Sino yung iniimbestigahan? Yung petitioner natin na nag-a-apply for probation. Ano yung kailangan niyang malaman? Information regarding the character of the petitioner, antecedents or yung previous conviction niya, if there is any, the environment, di ba? The mental and physical condition niya, kasi nga sabi natin kanina, pwede yang maging grounds kung ikaw ba ay bibigyan ng korte ng probation or not. Kasi possible kung hindi ka ayos mentally, di ba? Pwede kang i-commit sa isang mental institution and whatsoever. So, pipili yung korte ng ibang mas magandang choice for you rather than putting you in the community na mas makakalala lalo sa'yo. What is the aim? With the aim of determining whether the latter is qualified and suitable for the release under probation. So, ibig sabihin, si post-sentence investigation sa kanya din nakasalalay, di ba? Kung magagrant ba yung probation or not. Di ba? The grant or denial is discretionary with the court kahit qualified pa siya. Depende sa magiging resulta ng post-investigation mo sa kanya or ng probation officer sa kanya. Kung maganda ba, di ba, yung nakita niyang background ng ating petitioner o nakita or na-assess ng ating korte na pangit, di ba? Pangit yung character, di ba? Yung environment niya, to be specific, yung community, nag-interview si probation officer, maraming kwento na tungkol sa kanya na ganto ganyan, di ba? The previous conviction, his mental and physical condition. So, maraming grounds, di ba, na pwede nating masabi na pwedeng magamit for the denial ng petition o nung giving or nung granting ng probation. And nakadepende yan again sa post-sentence investigation na gagawin ni probation officer, di ba, through his report na ibibigay naman kay court. In short, again, para ma-assist, di ba, yung court in determining the most appropriate sentence. Ikaw ba ay sa loob, iserve mo yung sentence mo sa kulungan o hahayaan kita sa labas kasi qualified ka naman at pasok ka dun sa mga grounds and qualification for probation. Okay, next. Ano ba yung stages ng post-sentence investigation? So, before that, We have pre-sentence investigation na tinatawag, madidiscuss natin sa mga susunod, and we have post-sentence investigation. And we are specific, kapag probation ang pinag-uusapan, post-sentence investigation ang kinokonduct. When we say post-sentence, di ba, yung investigation is ginagawa kapag ikaw ay nabigyan na ng sentence. Kaya nga post, meaning to say, after, di ba? After ka mabigyan ng sentence, magkakaroon ng investigation. Yung pre-sentence, before ka pa, di ba, bigyan ng sentensya, that is pre-sentence investigation. Again, we are specific kapag probation, post-sentence investigation. Kasi minsan, PSI, parehas na pre and post, nagagamit at napapagpalit nila. Alam naman natin, again, tandaan lang, before the giving of sentence, and then post-sentence, kapag may sentence na binigay kay convicted offender, kinokonduct po ang post-sentence investigation. And ano yung stages natin? Kaunahan is the preliminary procedure, na kung saan dyan na na-receive ni probation officer yung order na galing kay court, di ba, na binibigyan siya ng trabaho to conduct the post-sentence investigation. That is the preliminary period or procedure. Dun pa lang niya na-receive, again, yung order from the court na kailangan niya mag-conduct ng post-sentence investigation. Pangalawa, the initial interview. Ano yung initial interview na tinutukoy natin? Na within the 5 working days, nung siya ay binigyan ng receipt or ng court order na mag-conduct na ng PSI, the probation officer shall interview the petitioner. So, kailangan siyang i-interview na kung saan kailangan din niyang mag-accomplish ng iba't ibang klase ng forms o ng worksheet na meron siyang ipapasign doon regarding the information na sa ating petitioner, doon sa ating aplikante for probation. And meron din dyan, for example, yung under oath na worksheet, same as doon sa waiver, di ba? Authorizing na yung probation administration to secure all other pertinent documents and information na makukuha sa kanya. Kasama yan sa initial interview. And then next, the investigation proper. And upon the completion of those worksheets and ng mga forms, yung probation officer na will conduct a thorough investigation dun sa antecedents, the previous conviction ng ating convicted offender, his mental and physical condition, his character, yung kanyang socio-economic status, and so on. Diba? As well as yung pag-i-interview din ng other person who was knowledge of the petitioner, as well as the victim or the relatives nung petitioner. So, ano yung meron dyan sa investigation? Aside from that, maging specific tayo. Kailangan niya ng local agency check, di ba? Kung saan i-review ng ating probation officer yung records niya, di ba? Sa barangay, sa city hall, yun yung tinatawag nating local agency check. While yung pangalawa, kailangan din ng NAC, the National Agency, at check na kung saan yung mga NBI and so on, National Agency check. And then lastly, yung tinutukoy natin na community check from local to national to community check na kung saan yan na yung interview ng probation officer within the community or environment na involved si petitioner. Yung mga kapitbahay niya, di ba? Yung mga taong malilapit sa kanya, the relatives, di ba? Yung residente dun sa lugar kung saan siya nakatira, ine-interview po yan ng ating probation officer to check his condition, to check his character, and to check his reputation within that specific na locality. So, yan yung meron sa investigation. The officer shall determine now and recommend the manner by which the petitioner will be supervised if granted probation based dun sa investigation na ginawa niya. And then lastly, the issuance of post-sentence investigation report. So now, nagawa mo na yung investigation. Ang trabaho naman ngayon ni probation officer is magawa ng kanyang report. Diba? Upon the completion of post-sentence investigation, kailangan niyang mag-submit ng PSIR to the trial court within the prescribed period, which is 60 days, diba? Nabanggit ko rin kanina na kung kulang pa talaga, you have to file an extension, di ba? Motion for extension. Pero yung extension na yon, i-request mo 15 days bago pa mag-lapse yung 60 days. Or it is upon the discretion of the court kung siya mismo yung magbibigay ng extension sa'yo. But yung pinag-uusapan lang natin dito, kailangan gumawa ng PSIR ni probation officer kapag natapos niya na yung PSI at isubmit niya within the prescribed period sa court. And that report shall be signed by the investigation probation officer and as approved by the head of the probation office bago niya yun ipasa sa ating court. So yun po yung stages natin kung ano yung meron sa post-sentence investigation. Okay, next. Period to resolve the application for probation. So the application for probation shall be resolved by the trial court not later than 15 days from the date of its receipt ng PSIR. Since probation is a privilege, its grant rests solely upon the decision of the court. Therefore, the court may grant or dismiss it. So, napakalinaw. Nabanggit ko na din naman kanina na yung period na meron ang court to resolve the application for probation is within 15 days. So, si 60 days, wag malito, for the probation officer yon para magawa niya yung PSI and the PSIR. So, now, nagpasa siya ng report kay court. And then, upon the receipt ng PSIR ng court, kailangan niyang i-resolve yung application for probation within 15 days. So, since the probation is a privilege, again, yun is nakasalalay, di ba? Solely upon the discretion of the court. And then, therefore, yung court, yung merong hawak kung siya ba is mabibigyan or madidismiss yung kanyang petition. So, automatically naman yan, kapag siya is nabigyan ng probation, the execution of sentence will be suspended. But again, subject, however, to the terms and condition na i-imposed by the court with the supervision of the probation officer. Kung ang kanyang desisyon is mag-grant ng probation, si court isususpend ang sentence and then magbibigay ng terms and condition na dapat niyang sundin and then magtatalaga ng probation officer na magsusupervise sa kanya. Or, i-dismiss niya nga. So, instead na for the grant of probation, mabigyan siya ng probation order na siya is marirelease na, kapag naman na-dismiss, sabi nga natin, madedenay, ang mabibigay sa kanya is a mittimus, na kung saan it is an order or warrant that committing a person to a prison. Mittimus order na kung saan an order that requiring a convicted offender na i-commit or na ikulong sa isang institution o to be specific sa presinto. In short, makukulong ka na. Kapag ikaw ay nabigyan, mapapalaya ka. Kapag na-dismiss or na-deny ang iyong application, mittimus ang mabibigay sa iyo instead of probation order and ikukulong ka. Next is the effectivity of the probation order. So, it is under the section 11 of the PD 968 wherein sabi dyan, a probation order shall take effect upon its receipt and on the same date the probation period shall commence unless otherwise specified by the court. So meaning to say, upon its issuance, diba, nung probation order na nagsasabi na nag-grant yung probation, yung application mo for probation, kapag yun ay na-issue na, diba, the probation order, yun na rin yung time, diba, na kung saan magsisimula na yung probation period mo. Again, from that time na na-issue or from the time na nabigyan ka na ng probation order, that is the time na magsisimula na yung probation period mo. Informing the offender ng consequences and explaining, di ba, that upon his failure to comply with any of the condition na binigay ng korte, siya is makukulong 'Di ba? He shall serve the penalty for those offense under which he was placed on probation. So, i-discuss din sa kanya yan. Aside from telling him na ikaw ay makakalaya na kasi nag-grant na yung probation mo, i-explain din sa iyo na kailangan mong sumunod, ito yung condition mo, and you have to comply. Again, magsisimula ang probation period upon its receipt by the petitioner. And on the same date, yung probation period mo is magsisimula na. Okay, next. Dahil nga nabigyan ka ng probation, meron tayong tinatawag na control and supervision of the probationers. That is under the section 13 of the PD 968 na kung saan the probationer and his probation program shall be under the control pa rin ng court na kung saan siya yung nagbigay ng probation subject to the actual supervision and visitation ng probation officer na itatalaga sa kanya. That is the part of the administrative function ng ating administrative body through the probation officer, di ba, ng ating PPA, the Parole and Probation Administration, na kung saan meron silang probation officer na magsusupervise sa ating probationer. Wherein kanina, di ba, na-discuss natin yung court function, nung function ng ating court, di ba, na kung saan siya yung nagbibigay ng sentensya as well as siya rin yung nag-grant or nagde-deny ng petition for probation. So now, under pa rin ng control ng korte yung ating probationer, at the same time, under din ng supervision ng ating probation officer yung ating probationer. So ganun po yun. Okay, so ito na nga yung tinutukoy natin kanina. Ano ba yung purpose ng probation supervision? Ano ba yung primary purposes kung bakit pa kailangan ng supervision? In the first place, 'di ba? Hindi ka basta lang nagpakawala ng normal na tao. So still criminal yung pinakawala natin, 'di ba? Wala tayong kasiguraduhan kung susunod ba 'yan doon sa mga kondisyon na binabasa kanya, at wala tayong kasiguraduhan kung magko-commit ba 'yan ng panibagong krimen na makakapagpalala pa, 'di ba, sa kanyang kondisyon, as well as makakasabit pa dun sa community na kung saan siya bumalik. First, to ensure that the probationer's compliance with the probation conditions specified in the probation order and the prescribed probation treatment and supervision program or yung plans na nilatag sa kanya. Automatic naman yan, the supervision para ma-supervise ni probation officer kung siya is nagko-comply. Pangalawa, to manage the process of the probationer's rehabilitation and reintegration into the community. Ang ating pong probation officer and through his supervision, siya po yung nag-aasikaso niyan. Diba? If there is any need, diba, for his rehabilitation and then as well as dun sa kanyang reintegration in the community, ayan po is nasa pamamahala na ng ating probation administration through the probation officer. At hindi na yan from time to time makikialam si court. If ever na lang na kailangan ng intervention again ng korte, since may control pa rin ang court sa kanilang dalawa over the probation officer and the probationer, so tsaka tayo lalapit sa kanya. But then again, di ba, nakasalalay or nakaatang totally yung supervision, yung pag-supervise kay probationer ni probation officer. Okay, last, to provide guidance for the probationer's transformation and development into a useful citizen for his eventual reintegration to the mainstream of society. So aside from the supervision, minsan di ba, ito is a personal touch na mismo ng probation officer natin sa mga probationers natin, na kung saan nararamdaman ng ating mga probationer na he is on his right path, na binabantayan siya, di ba? Tinutulungan siya ng probation officer para magbago, di ba? Instead nga naman na nasa kulungan ako, di ba, napakapalad ko na nabigyan ako ng probation and then nabigyan ako ng gantong klaseng pagkakataon na mamuhay sa labas, di ba? At binabantayan pa ako ng probation officer to monitor me from time to time, kasi para din naman sa akin yung rehabilitation program or yung supervision program and plans na nilatag para sa akin, di ba? Nakakatulong naman talaga for the transformation and development, di ba, ng ating mga probationer para sila is maging useful citizen, di ba? Maging kapaki-pakinabang at ma-regain nila yung kanilang confidence, di ba? Sa community, di ba? And so on. So, yan po yung ating mga primary purposes of probation supervision. Okay, next, change of residence. Sabi nga natin kanina, di ba, ikaw is under pa rin ng control ng court kung saan siya yung nagbigay sa'yo ng probation, as well as din sa supervision, of course, ng probation officer na binigay sa'yo. So now, ano yung mangyayari kapag ikaw is lumipat, di ba, ng iyong titirahan? Di ba? You have to change your residence, di ba? Dapat, of course, meron kang sapat na dahilan. So, kapag nangyari to, whenever a probationer is permitted to reside in a place under the jurisdiction of another court, so meaning to say, naaprubahan ni trial court, yung request mo, nalilipat ka, yung control ngayon is matatransfer din, yung control over him or the probationer shall be transferred also to the executive judge of the court of first instance of that place. So, ibig sabihin, ililipat na yung control or yung jurisdiction over that person or yung probationer kung saan lugar siya lumipat. And in such a case, kasama of course doon yung copy of probation order, the investigation report, the PSIR, and other pertinent record, kasama yon na ibibigay sa ating executive judge na kung saan siya na yung may control over that probationer. Thereafter, the executive judge to whom jurisdiction over the probationer is transferred shall have the power with respect to him that was previously possessed by the court which granted the probation. So now, again, ang pagpapalit po ng lugar kung saan titira ang ating probationer is depende pa rin yan sa discretion ng court. Hindi porket gusto mong lumipat, itatransfer na lang basta-basta. Sabi nga natin, once na ikaw ay napalaya and under ka ng probation, you have to follow kung ano yung condition na ibibigay sa'yo ng korte. At isa to doon, na kung saan hindi ka pwede basta-basta magpalit, diba? Lumipat kung saan-saan at gumala ng kung saan-saan nang walang paalam sa korte. So meaning to say, if you want to change your residence kung saan ka titira, kailangan mong mag-request for change of residence sa ating korte. Citing the reason kung bakit gusto mong lumipat, di ba? The reason kung bakit ka nagre-request for change of residence. And isasubmit po yon sa probation office. And then, lastly, that is still for the approval of the trial court. Nakadepende pa rin sa trial court na may control over you if he will grant your request. At if ever man na ikaw ay payagan na lumipat, eto na nga yung mangyayari. Kung saan ka lumipat, yun na yung may control over you and then itatransfer yung papers mo as well as yung control again over you, iba na yung hahawak sa'yo at iba na yung magbabantay sa'yo within that specific place na gusto mong lipatan. Okay, next naman. If you want to travel outside the place that you are residing, kung gusto mong mag-travel outside, di ba, ano yung mangyayari? Probation officer authorized the probationer to travel outside the area of the operation for a period of 10 days but not exceeding 30 days. So, ibig sabihin pwede pala. So, ipapayagan ka, di ba, to travel outside the area of the operation for period of 10 days, pero dapat hindi mag-exceed ng 30 days. If ever na 30 days, di ba, kung gusto niyang mag-travel for up to 30 days outside the operational or territorial jurisdiction na kung saan siya nagko-conduct or saan siya nag-undergo ng kanyang probation, di ba, at least 5 days before the intended travel, kailangan niyang magpaalam or mag-request for outside travel. Again, kung ang probationer natin is magta-travel ng up to 30 days outside the place na kung saan siya naninirahan or may jurisdiction over him, kailangan niyang mag-file ng request for outside travel 5 days before the travel. Ibig sabihin, Ngayon ako mag-travel, 5 days before ngayon, kailangan magpaalam na ako. Kailangan mag-request na ako to travel outside and again, subject for the approval ng ating probation office o ng probation authorities natin. Hindi yan basta-basta nagpapaalam ka lang, yan ay depende pa sa kanila kung papayagan ka. And then lastly, if more than 30 days, ano yung mangyayari? If you will request an outside travel for more than 30 days, the said request shall be recommended by the probation office to the court for his approval or for its approval. So meaning to say, kapag lagpas ng 30 days yung gusto mong i-request, 'di ba, to travel outside, ang mangyayari, yung request mo shall be recommended from the probation authorities or yung probation office na pinagpasahan mo, that will be submitted now to the trial court at yung trial court ngayon yung mag-a-aproba sa'yo. Yung una, if yung period is 10 days but not exceeding 30 days, magpapaalam sa ating probation officer, and then si probation officer yung bahalang mag-authorize. Next, kapag 30 days, kailangang magpaalam, magpasa ng request to travel, and then aaprubahan ng probation office na tinatawag natin. So, to be discussed sa mga susunod, ano ba yung office na tinutukoy natin? So, si probation office yung mag-a-approve if that is 30 days. And then, kapag more than 30 days na yung iyong request to outside travel or for outside travel, yan is ipo-forward ni probation authority or na probation office ating court for its approval. So, nakadepende na kay korte kapag more than 30 days yung outside travel mo kung yan ba ay pagbibigyan or not. So, now, kung kanina meron tayong absconding petitioner, when we say petitioner, yung mga aplikante pa lang natin for probation, meron tayong tinatawag ngayon na absconding probationer. If ever, for example, na nabigyan siya ng chance na makalabas, diba, maluwag yung supervision over him, hindi na siya nagpakita, hindi na nagbalik, wala nang appearance, ang tawag natin sa kanya ngayon is absconding probationer. Wherein si probationer, ang tawag po sa tao na nabigyan ng probation, probationer. Okay, next, the early termination of probation. So, may pagkakataon na mas napapaaga, di ba, yung termination ng period of probation mo. So, ano yung mga recommendation or yung recommended na pagkakataon for the early termination of their probation period? First, those who are suffering from serious physical or mental disability. At yan na nga yung mga example natin, yung mga deaf, mute, di ba? Yung may mga ketong, di ba? Lepers, may leprosy, crippled or yung mga ating mga pilay, di ba? Other bedridden na mga probationer natin, yung mga matatanda na probationer natin, and so on. Kung saan, yun is pwedeng maging grounds for the early termination ng kanilang probation. But, hindi ibig sabihin nun, di ba, na hindi na sila mag-serve ng kanilang probation period outside, mas mapapaaga lang, di ba, yung kanilang termination. Next, those who do not need further supervision as evidenced by the following. So, yung mga nagpamalas talaga ng kabaitan outside the penal institution, kung saan first, di ba, consistent siya, di ba, and yung religious compliance niya with all the conditions imposed in the order granting probation. Dalawa, merong positive response, di ba, dun sa programs na nilatag sa kanya, designed for their rehabilitation. So, sabi nga natin, individualized treatment yan. So, merong kanya-kanyang programs na nilatag sa kanila. Kapag maganda yung takbo, maganda yung response niya dun sa programs na nilatag sa kanya, di ba, under ng supervision ng probation officer natin, possible yan na maging grounds for early termination. Pangatlo, significant improvements in their social and economic life. Lalo na kapag nakita natin, 'di ba, na nakikisama siya, nakikihalubilo siya ng maayos, 'di ba, sa lugar na kinabibilangan niya, as well as, 'di ba, yung kanyang pamumuhay, mas pinagbibigyan niya ng importansya ngayon yung kanyang kabuhayan, 'di ba, yung kanyang status sa buhay, and so on. So nakita mo na may improvement yung kanyang status, all in all, yung kanyang lifestyle, and so on. Next, absence of any derogatory record while under probation. So, matik na yan. Kung wala kang ibang other na record, di ba, na nakumit, na action na nakumit that is in violation of the terms and condition and while under probation. So, pwedeng-pwede. Next, mark improvement in their outlook in life by becoming socially aware and responsible members of the family and community. So, especially kung ikaw ay padre de pamilya, di ba? Kung ikaw is mas pinili mo, di ba, natutukan yung pamilya mo, magtrabaho ng maayos, and then i-improve yung buhay mo, para maging pakinabang sa lipunan. Instead of nung una, di ba, pabigat ka na sa pamilya mo, pabigat ka pa sa lipunan, and so on. And then, last is significant growth in self-esteem, self-discipline, and self-fulfillment as a whole. Yan na yung resulta. But, provided that the probationers involved have already served 1/3 of the imposed period of probation, and provided further that in no case shall the actual supervision period less than 6 months. So, yan lang yung ating condition na pwede ka mabigyan ng early termination through these grounds basta provided na ikaw ay nakapag-serve na ng at least 1/3 ng iyong probation period. And again, provided further that no case shall the actual supervision period be less than 6 months, not less than 6 months, and at least 1/3 of the probation period is na-serve mo na. And then next, those who have to travel abroad due to any of the following may approve overseas job, contract, or any other similar document. So, automatic naman yan. Isang patunay yan na ikaw ay naghahanap ng trabaho at gusto mong mabuhay na ng matiwasay, gusto mong mag-focus sa pamilya mo, gusto mong mag-focus para mapaangat yung sarili mo sa buhay, especially in terms of financial, di ba? Kailangan mong magtrabaho, so bakit pipigilan kung ikaw ay naaprubahan na magtrabaho sa ibang bansa? Opportunity mo na yan para ikaw ay lumago sa buhay, di ba? Unapproved application for scholarship, di ba? Nag-aral, observation tour or study grant for a period not less than 6 months. So, pwede po yan. Unapproved application for immigration, mga patakas na, pwedeng gawing style. Pero, of course, kung yan is in good faith, di ba? Napakagandang opportunity yan para ikaw ay matulungan na magbago. And then, an approved application to take the bar and board examination. So, hindi naman lahat ng kriminal natin is walang pinag-aralan. So, nangyayari yan na kung saan, sabi nga natin, nabigyan ng second chance, nagtino, gustong pagandahin yung buhay, di ba? Baka makasagabal pa yung probation period mo or yung probation program sa'yo para makapag-focus ka dun sa bagay na yan. So, possible na through this kind of grounds, diba, na nag-improvement sa life mo, ma-early terminate yung probation order sa iyo o yung period of probation na kailangan mong i-serve. Kasi, meron ka ng patutunguhan sa buhay, kumbaga. So, mag-focus ka na dyan. Next. Okay, last is for those to have to render public service. Diba? Ikaw ay na-elected to any public office or having been appointed to any public office. So, possible na ikaw is ma-early terminate sa iyong probation program or period kapag ikaw is to render any public service sa ating community. Ikaw is kailangan mo or ikaw is appointed or elected to any public position or office. And then next, How long is the period of probation? So, ito na yung pinag-uusapan natin kanina. Gaano ba katagal yung period of probation? So, nabigyan ka ng probation, gaano ka ba katagal magsaserve outside habang ikaw ay control ng ating korte at ikaw ay binabantayan ng ating probation officer? So, gaano katagal yung service mo while under probation? Okay? Not more than 2 years if the sentence of the offender is 1 year or less, and not more than 6 years if the sentence is more than 1 year. So, yung period of probation mo, first, we have two. Meron po tayong dalawang period of probation. Una, kung ang sentence mo is 1 year or less, ang period of probation mo is dapat hindi lalagpas ng 2 taon. Pangalawa, kung ang sentence mo, di ba, is more than 1 year, yung period of probation mo, hindi dapat lalagpas ng 6 na taon. Okay, ulitin natin. If the probationer is sentenced to a term of imprisonment, kapag not more than 1 year, meaning to say, 1 year or less, yung tagal ng probation period mo, hindi dapat lalagpas ng 2 years. And in all cases, if he is sentenced naman to more than 1 year, the said period or yung period of probation now shall not exceed 6 years. So, yun po yung period of probation natin. But take note, the probation period may either be shortened or pwedeng mas mapahaba, di ba? But not to exceed the period set in law. Kung yan ay 2 years yung pinakamatagal, yung 6 years ang pinakamatagal, hindi dapat lumagpas pa doon. For example, nabigyan ka ng, sabi not more than 6 years, binigyan ka ng at least 5 years. Pwede yung mapahaba hanggang 6 years, depende kung papaltan yan ng ating court. For example, nagpasaway ka, dapat sige 3 years lang probation period mo. And then nagpasaway ka palalo, hindi ka sumusunod sa probation program mo, sige, habaan pa natin kasi mas kailangan mo pang tutukan. So, ginawang 6 years. So, what I'm trying to say is, kahit ano pa yung probation period na ibigay sa'yo, hindi pa rin yan fixed kasi it may either be shortened or made longer, again, but not exceed to the period set in law, which is 2 years and 6 years. And sabi nga natin kanina, the period of probation, di ba, is no longer necessary or pwede siyang ma-early terminate kung makita natin na yung probationer is no longer a threat sa society at he has already satisfactorily na nag-reintegrate or naging makabuluhan yung kanyang ganap inside the community or into the community. And then, it may be shortened, di ba? The period may be shortened. But if there is a need for the protection, again, ng community or ng society, yung adjustment or yung pagpapahaba ng period of probation is possible. Di ba? Longer, pwede, but not beyond 2 and 6 years. Ibig sabihin, kung pang 2 years yung maximum mo, kasi 1 year or less yung kaso mo, hindi lalagpas ng 2 years dapat pag pinahaba ko. And then kapag pasok ka sa 6 years ng probation period kasi more than 1 year yung sentence mo, hindi dapat lalagpas sa 6 years yung extension ng probation period na ibibigay sa'yo. So again, yun po yun. Kapag 1 year or less yung sentence mo, yung probation period mo, basta hindi lalagpas ng 2 years. So ibig sabihin hindi fix yan na 2 years. Basta wag lang lalagpas ng 2 years. And then kapag more than 1 year yung sentence mo, hindi lalagpas dapat ng 6 years ang probation period mo, tapos ang usapan. Pwedeng ma-adjust, pwedeng mapahaba, pwedeng mas mapaikli, depende dun sa status ng ating probationer. Now, we have conditions in the grant of probation. Yung tinutukoy natin kanina na paulit-ulit that once na ikaw ay nabigyan ng probation, you will now be under the condition na i-impose sa'yo ng court. At ano yon? First, the probationer must present himself to his probation officer within 72 hours. So, it is being required by the court na magpakita siya sa kanyang probation officer within 72 hours from the receipt of the said probation. So, nababaan ka na ng probation order, meaning to say, nag-grant yung probation petition mo. And then, after that, within 72 hours, kailangan mong magpakita sa iyong probation officer. Pangalawa, report to his probation officer in charge of his supervision at least once a month. So, napakalino naman, at least once a month, kailangan niya mag-report sa kanyang probation officer na in charge of his supervision, yung nag-supervise sa kanya, once a month. Pangatlo, diba, not to commit any other offense or violation or else ikaw ay papatapon ulit sa kulungan. Pang-apat, to comply with any other conditions imposed by the court. So we have other discretionary and optional condition na pwedeng ibaba sa iyo ng korte aside from the probation program na makatutulong sa iyo for your rehabilitation. So bukod pa po 'yon. So now, ito po yung condition or yung general na condition na gusto na pinapatupad ng korte. Dahil ang court ay may control pa rin over the probationer kahit sabihin na natin na tapos na yung trabaho niya sa pagbibigay ng sentensya at paggagrant ng probation. So ito po yun. And we have two, di ba? We have two mandatory or built-in condition na kung saan ito yung pinakadalawa na mandatory condition na ipinapatupad ng korte na dapat sundin ng ating probationer. The probationer must present himself to his probation officer within 72 hours and to report to his probation officer in charge of his supervision at least once a month. And again, kapag ikaw ay hindi sumipot, diba, hindi ka nagpakita, hindi ka nagre-report, ang tawag against sa'yo is absconding probationer. Hindi po petitioner kasi na-approve na yung petition mo. So now, ang tawag sa'yo is probationer na and we are now referring kapag ikaw ay pasaway as absconding probationer. We have discretionary and other condition nga na tinutukoy natin na pwedeng ipatupad or depende pa rin talaga sa discretion ng court kung ano ba yung gusto niya na makatutulong again still, di ba, sa kung ano yung best para sa probationer natin as well as dun sa community or dun sa family na kinabibilangan niya. First, cooperate with a program of supervisor. Matik naman yan. Pangalawa, meet his family responsibilities. Kung ikaw is working, nung ikaw ay nakulong, kung ikaw is a provider ng iyong pamilya, di ba? Panagutan mo and then magtrabaho ka and so on. Kung ikaw ay padre de pamilya, panagutan mo yung pagiging tatay sa iyong pamilya. Kung ikaw ay nanay, alagaan mo ng matiwasay ang iyong mga anak and so on. Next, devote himself to a specific employment and not to change his said employment without without prior written approval of the probation officer. So, as much as possible, i-require ka, di ba, ng court na maghanap ng trabaho kung wala kang trabaho and not to change said employment without prior written approval ng iyong probation officer. Next is to comply with the program of payment of civil liability to the victim na kung saan kailangan niyang magbayad, di ba, ng damages, di ba, na na-cause niya dun sa kanyang biktima or if there is any injury or financial loss na nangyari dun sa kanyang victim. So, sabi nga natin, any person that is criminally liable is also civilly liable. So, kailangan niyang panagutan yung kanyang civil liability sa kanyang biktima. Next, undergo medical, psychological, and other any examination na makatutulong sa'yo, di ba? And remain in that specific institution when required for that purpose. Kung kailangan mong magamot or ma-cure if there is any finding na pwedeng mag-cause sa'yo para, for example, physically or psychologically, di ba, mas lalo kang mapasama habang ikaw is nag-undergo ng iyong probation program. So, depende yan. Again, kay court, kung re-require ka niyang gawin yung mga bagay na yan. Lalo na kung nakikita niyang kailangan. Pursue a prescribed secular study or any other vocational training. So, kung nag-aaral, di ba, kailangan, di ba, pwedeng i-require, lalo na kung ikaw is, for example, hindi nakapagtapos, nakakommit ng crime, 19 years old, bata pa, pwede pa mag-aral, natigil lang nang dahil sa nakakommit ng crime. So, as much as possible, di ba, i-encourage ng korte na magpatuloy ka sa pag-aaral mo, o kung kaya naman, any other vocational training na makakatulong na ma-improve mo yung sarili mo at matulungan ka sa iyong economic status. And then, attend or reside in a facility established for instruction or reaction of person on probation. And then, next, refrain from visiting houses of ill repute, di ba? Houses ng prostitution o yung mga warehouse na tinatawag natin. So, as much as possible, kahit nga yung mga sabungan or any other na places na matutukso ka na magbisyo, mag-commit, diba, dun sa prostitution, and so on, as much as possible, pinagbabawalan po natin yan kasi lalo kang makukurap. Pinayagan ka na nga makalaya, pero ginamit po pa yon as privilege para mag-happy-happy pa sa labas. So, no. Next, abstain from drinking intoxicating beverages to excess. So, at least in moderation, or as much as possible, refrain, diba, to abstain from drinking kung i-require ng court sa'yo, yung mga alcoholic beverages natin, and so on. Next, permit the probation officer or unauthorized social worker to visit his home and place of work. So, automatic naman yan kasi nga under supervision ka. So, dapat, diba, payagan mo si probation officer mo to visit you sa iyong tahanan or dun sa place of work mo para ma-monitor ka and to check if there is any progress sa iyong kalagayan. And then, next, ito yung isa kanina, you have to reside at premises as approved by the court and not to change your resident without prior written approval. Kaya nga kapag ikaw ay lilipat, kailangan pang may approval na galing sa court and even the outside travel dun sa jurisdiction o dun sa outside ng residence mo, kailangan mo pang magpaalam kasi still ikaw is under ng control ng ating court. And then lastly, satisfy any other condition related to the rehabilitation of the probationer and not unduly restricted of his liberty or incompatible with his freedom of conscience. So, yan po yung mga discretionary and any other condition na pwedeng ibigay ng court sa'yo para matulungan ka just to rehabilitate you at matulungan ka para magbago kasi hindi naman to para kung kanino. Para sa kanya din naman, para sa probationer pa rin naman natin to. Para matulungan siya na tuluyang magbago. Okay, next. What happens to a probationer if conditions of probation are violated? So, what will happen sa ating probationer kapag naka-violate siya ng mga conditions of probation or while ongoing pa yung period ng kanyang probation. So now, the court may modify, di ba, the conditions of probation or revoke the same. If the violation is serious, the court may order the probationer to serve his prison sentence. The probationer may also be arrested and criminally prosecuted if violation is a criminal offense. So ano ang mangyayari? If the violation is serious, di ba, the court may order the probationer to serve his prison sentence. At hindi doon counted yung period of probation na na-serve niya na sa community. Sabihin natin na nakapag-serve na siya ng 1 year. So, hindi yun makakount, hindi yun maleles sa kanyang original sentence. Kasi ang sabi natin, siya is pababalikin, ikukulong sa kulungan at he will serve his original sentence. So, hindi counted yung kanyang serving of sentence while under probation, but rather inside the institution, back to zero siya. So, he will now serve his original sentence. And he may also be arrested and criminally prosecuted kung ang violation naman niya is a criminal offense. Diba? Kapag siya is na-violate niya lang yung condition ng probation, ibabalik lang siya sa kulungan. Ikukulong lang siya. Kapag naman siya, of course, is nakakommit ng criminal offense, aside from ibabalik siya sa kulungan to serve his original sentence, ipoprosecute pa siya for another crime na nakommit niya. Diba? Kung sa example, nakapatay siya habang siya is on probation, So ngayon, you will now criminally prosecuted dun sa crime na nagawa mo at another offense yan, bukod dun sa existing na crime na meron ka or dun sa existing sentence na meron ka na kung saan nabigyan ka na nga ng probation pero nasayang pa. At sabi nga natin, di ba, the court may modify. Pwede niya yung mapalitan, di ba? Pwede niya yung mabago yung condition ng probation if there is any violation na nagawa. And yung modification niya is depending dun sa nature and seriousness nung violation na nagawa nung probationer. So, hindi naman ganun lang basta-basta na mag-modify yung court natin. So, kailangan niyang na-establish muna ng ating probation officer at kailangan niya muna yung ma-report sa ating court. So, kapag nakita ng court that there is a valid reason na siya is dapat ma-modify, o kaya naman, let me say na ganito na lang, na yung violation niya is na-establish. Napatunayan na meron siyang violation na na-commit against dun sa condition of probation na binaba ng court sa kanya. Ang court now ay meron dalawang choice. It is to revoke, di ba? Mabawi yung kanyang probation or continue yung probation pa rin pero imo-modify na yung condition. So, yun yung magiging magiging scenario natin kapag ganyan. If there is any violation na na-commit. Pero ibang usapan na, di ba, kapag criminal offense yung ginawa mo. Ibabalik ka na nga, di ba? Mare-revoke na nga. Isa-serve mo na yung sentence mo sa kulungan and then ipoprosecute ka pa, di ba, ng bukod dun sa krimen na nagawa mong panibago. So, yun po yung mangyayari. Note, if the court finds that the probationer is guilty of serious violation, ay nabanggit ko na nga, of the condition of probation, he may be ordered to serve the original sentence imposed on him. So, yun na nga binabanggit ko kanina. Kapag napatunayan na merong violation talaga against the probation order, or dun sa condition ng probation niya while undergoing ng probation, di ba? The court may order to serve the original sentence depending dun sa seriousness ng nagawa niya. Kung hindi naman ganun ka-serious, pwede siyang ma-modify, pwedeng mabago, pwedeng ang maging concern natin, yung sa modification is mapahaba yung period of probation mo and so on. Pwedeng madagdagan yung condition na dapat mong sundin. So, yun yun. Okay, next. Ito na nga yung paulit-ulit nating sinasabi kanina. Absconding probationer. A person whose probation was granted, nabigyan na ng probation, ibig sabihin, probationer na ang tawag sa'yo. From petitioner, nag-a-apply ka for probation, naging probationer ka na. But failed to report for the supervision or fails to continue reporting for supervision or whose whereabouts are unknown for a reasonable period of time. Kung ikaw ay naglaho na lang na parang bula at hindi ka na nag-report sa ating probation officer, ang tawag ngayon sa'yo is absconding probationer. Pero kung ikaw naman is ginawa mo yan, naglaho ka rin ng parang bula habang ongoing pa yung petition for probation, ibig sabihin hindi pa nagka-grant, ang tawag sa'yo again is absconding petitioner. Ikaw ay aplikante pa lang, nagpe-petition ka pa lang, nagpasaway ka, di ba, tumakas ka na, naglaho ka na, absconding petitioner. Absconding probationer kapag nag-grant ka na ng probation, nabigyan ka na ng probation, and then dun ka lang nagloko. Absconding probationer. Next, the violation or infraction report. So, ano yun? A report na kung saan we are referring to the report submitted by the probation officer on violation committed by a probationer of the conditions of his release on probation while under supervision. So, ito na nga yung binabanggit ko kaninang report. Kapag na-establish dun sa report na pinasa ni probation officer na meron talaga siyang violation na nagawa, so possible na ma-revoke yung probation yung probation order ni probationer o kaya naman ma-modify yung condition nito. So, ang tawag dun sa report na yon is violation report or infraction report. Okay, and then ulitin lang ulit natin, the revocation of probation, mangyayari yan kung ikaw ay may failure to comply with any condition, kung hindi natataba yung modification ng iyong period of probation. Last resort ng ating korte is to revoke your probation order. So, ikaw ay ikukulong, 'di ba? Lalo na kapag napatunayan yung seriousness ng violation na nagawa mo or yung failure mo to comply with the condition na ibinabasa ng korte. And then, one last thing na pwedeng maging reason para ma-revoke o mabawi ang iyong probation is that nakapag-commit ka nga ng another offense. O automatically po, ikaw is ipapatapon sa kulungan. So, yan po yung mangyayari sa atin. And then, lastly, grounds for determination of the probation cases. So, ano ba yung grounds para ma-terminate o matapos na yung iyong probation period? Of course, first, automatically, tapos na yung iyong probation period. You have successfully completed the probation program. Doon sa probation period na binigay sa'yo, natapos mo siya within the prescribed period na binigay ng korte sa'yo. Okay, pangalawa, diba yung kaninang mga nabanggit natin, because of probation revocation. Automatically, tapos ang ating probation order o yung ating probation program na binigay sa ating probationer once na-revoke yung kanyang probation. So next, the death of the probationer. So, hindi na kailangan questionin kapag namatay po ang ating probationer habang siya is under ng such a period na siya is nagsiserve ng kanyang probation, automatically mataterminate po yung kanyang probation program. Early termination of the probation order, na kung saan yung diniscuss natin kanina. Ano ba yung mga pwedeng reason o condition na pwede kang mas mapaaga? Diba? Yung nakatanggap ka ng public position or ng trabaho, diba? Outside, abroad, and so on. Yun yung mga possible, yung mga na-discuss natin kanina. Again, yan po yung ating grounds for the termination. It's either ikaw is na-complete mo, natapos mo, na-revoke yung iyong probation, namatay ang ating probationer, and then yung mga early termination na condition na na-discuss natin kanina. And any other analogous causes or reason on a case-to-case basis as recommended by the probation office and approved by the trial court. So, meron tayong ibang mga cases na kung saan depende na yan dun sa reason, each probationer natin, kung ano yung kanilang possible na maging dahilan para mas mapaaga, para ma-terminate, yung kanilang probation period o yung kanilang probation program na nailatag sa kanila. And then, take note that kailangan po ng termination report 30 days before the termination period. So, kailangan po na yung ating probation office ay mag-submit sa trial court na may hawak pa rin sa kanila ng officer's final report na kung saan yun nga yung tinatawag natin na termination report within 30 days before the expiration of the period of the probation. So, ang mangyayari, 30 days bago matapos yung probation period, kailangan maggawa ng termination report yung ating probation office through the probation officer at ipapasa po sa ating trial court na kung saan nandun yung brief personal circumstances ng ating probationer, yung kanyang criminal case number, and so on, yung other information about his case, diba, the prescribed probation treatment and supervision program na nilatag sa kanya, and then kung ano ba yung response niya dun sa treatment and program, and then lastly, nakapaloob po of course sa termination report na meron dong recommendation to discharge the probationer from probation and the restoration of course of all his civil rights. Kasi yun po ay nawawala once na ikaw is napatunayan na nagkasala. And then such other relevant and material facts and information which may be required by the trial court. At kapag tapos na po yun, di ba, na expired na yung period of probation, automatically ikaw po is i-discharge na ng ating court. Diba? After the expiration of the original or the extended probation man na binigay sa'yo, diba? The trial court now may order the final discharge of the probationer. Diba? After first finding that he has fulfilled the probation terms and condition. based dun sa termination report ng ating probation office, and therefore, di ba, the probation supervision now is deemed terminated. So, dun na po natatapos yon. Once na okay na, di ba, natapos na yung probation period, automatically, wala na pong control over you, yung court na kung saan may jurisdiction sa'yo at first, kasi siya yung humawak ng kaso mo, and siya yung merong control sa'yo habang ikaw is ongoing sa iyong probation period. So now, dahil terminated na yung iyong case or yung iyong probation program, di ba? Ngayon, ikaw po is i-discharge na. Again, the court or the trial court now will order the final discharge of the probationer. So, ganun po tumatakbo ang ating probation.